You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is In Re Amendments to the Florida Rules of Traffic Court.
Good morning. May it please the court, opposing counsel. My name is William Abramson, and I'm a member of the Florida Bar Traffic Rules Committee, and it is a privilege to appear before this court today to make two requests of this honorable court. The first issue is an amendment to the traffic rules of court, which would allow an individual who is charged with a traffic infraction to not be compelled to be a witness against him or herself, similarly as in a criminal proceeding.
Now, you said something, and I know this is a rule being proposed by the entire committee, and you said it would give the defendant the right not to be compelled to give testimony. But my problem is that that's a substantive issue as to whether they have that right, or whether they don't have the right, and whether in the context of a traffic infraction, there are cases that talk about whether there is an impending prosecution. So I don't see how we, in a rules case, make a substantive decision.
I'm going to ask the court to look at the Levitt's opinion, which was the first opinion issued by this court, where this court held that even though it's a traffic infraction, individuals have all the constitutional due process rights that were available to them when the case was a criminal case.
Was that a case well, again, if the law is that they have that right, then we don't need to put it in the rules. We don't put in the rules, the rules are about procedure, not substance. And I just don't, and again, I don't think the Levitt's case actually deals with the Fifth Amendment self-incrimination. And I understand that this would be a concern for an unrepresented litigant who might be testifying. And I don't know that anything prevents a judge from giving some cautionary statements, but this would actually be a rule, a command that, how would it be used in the courtroom setting? How would it actually be executed?
When the court does its initial explanation at the beginning of all traffic proceedings, the court gives initial explanation as to how the proceedings are going to take place. And all the court would need to do at that point is remind individuals that are representing themselves that as the defendant, they are not required to be a witness in the case.
And now, is that done presently by judges?
No. That is not a part of the initial colloquy.
So we would be imposing by rule a substantive addition to a colloquy?
Well,
see, and again, this is not, we're here on a rules case, not on a case in controversy. So, and I don't, I know there's opposition from the county court judges and from, it seems pretty unanimously from the judges that this is not something that they do now, and don't think that it is substantively a requirement. Now, I don't know I agree or disagree with that, but I don't think there's a case clearly on point that says it's mandatory in all cases.
I would just ask the court to look at Levitt's and then State versus Johnson, which indicate that even though the process was decriminalized, there was never an intent to reduce individuals' rights. And the Constitution allows an individual to exercise the right to remain silent.
How is it that an accused in a traffic infraction is compelled to testify against himself, to provide that? How does that happen?
A judge would then, or a hearing officer would turn to the defendant who's standing there after the police officer, and then any witnesses that the state had subpoenaed to be there would then turn to the defendant and ask them if they have anything to say or if they want to testify. But they should be told they don't have to. Maybe the state hasn't met its burden of proof. This is a criminal standard. An infraction has to be proved beyond a reasonable doubt. That is a criminal standard.
Well, typically, in infractions, typically there isn't a prosecutor present.
Correct.
So, are there instances in which judges engage in a dialogue or a colloquy or question and answer type situation with an accused?
Absolutely, and even more so, there have been situations where judges have indicated you have no choice. You have to testify. You cannot remain silent at this hearing, and you could be subject to contempt of court for not answering a judge's questions during the case. Under the law, because it's a traffic infraction hearing and there are no prosecutors, the judges this court have held are obligated to ensure the orderly progress and process of a traffic infraction hearing. But at what point does it become an orderly process and become a prosecution when the judge then just...
Here's my concern, and my concern, cases involving an accident, or say somebody runs at red light or stop sign or speeding, and the officer at the scene issues a citation for speeding, running a red light, or whatever. And that's what's before the traffic infraction officer. Meanwhile, there were serious injuries or perhaps even a death in the case. The highway patrol will usually do a homicide investigation, which may take months. And eventually they will provide a report of the homicide investigation to the state attorney, who will decide whether to proceed with charges, vehicular homicide, manslaughter, whatever. But in the meantime, while that investigation is being conducted, these infraction hearings are taking place. And a defendant, an accused, may come in and may make statements in defense of running a red light or whatever, or even plead guilty to those offenses. Now, would that be admissible later on if that person is charged with manslaughter or vehicular homicide?
Absolutely. If the person chooses on their own, not being compelled by the state to be a witness in a case, then that statement can be used.
But not the plea. There was some law out there that those could not be used.
Accident report privileges cannot be, but if you testify in the open court, then that would be fair game.
But not the plea, again, going back to that.
I'm sorry?
But not the plea.
Unless it's a plea. Well, unless
because
it's a plea.
We're talking about civil. Yeah. We're talking about a civil infraction. And isn't it clear, there's case law on that a plea in a civil infraction is not the same as a plea in a criminal proceeding?
Although in civil cases, if you do plead guilty to the infraction, then it would take away your right to challenge the nature of the your responsibility for the accident in a civil trial down the road. If you plead guilty, you plead no contest, then obviously it would not be used against you.
Are you sure? You sure that's the law?
A plea of guilty, it's my understanding. If you plead guilty to running a stop sign, causing an accident, in a civil proceeding. If you plead guilty, it's my understanding.
I'll check. I don't believe that's the case.
I don't think so.
If the basis for the vehicular homicide case or the manslaughter charge that may come about later, if the basis for that is running the red light or speeding at a high rate of speed, going 95 in a 35-mile zone, if the basis for the homicide charge later on is that speeding, that infraction, would a guilty plea to that infraction be admissible as evidence that he committed the crime?
Not in a criminal proceeding, but I believe in a civil proceeding for money damages. Okay. It would be if it's a guilty plea.
See, what I think, though, what's going on here, at least from my point of view, is there may be a difference between whether you're testifying or paying a civil penalty, which there's a statute that expressly says that's not used. But the first question that Justice Labarga asked you is someone really being compelled to give testimony if nobody is calling them to the stand? And what you're saying is this needs to be done not where a defense lawyer is representing the defendant, because in that situation the defense lawyer will say don't testify or do testify, depending. But you want to make sure that the advice is given to the self-represented litigant. Is that what I...
Absolutely. That is a major component. The second component...
And I appreciate it, but the way the rule reads is it just says testimony of accused. No accused person shall be compelled to give testimony against himself or herself. And I'm still trying to understand how that rule would work. It doesn't say who's supposed to advise the traffic defendant, at what stage. Is it at the point before they plead guilty? And so that's why it seems that this is just not the right forum to try to make this decision.
We would respectfully disagree that there is a opening remarks that are made by the judge or traffic hearing officer that explains how the proceeding is going to take place. All they would have to do is add one more sentence.
But is the colloquy that is given, is that in the rules?
It's in the case law, and I believe it's in the rules as well, the explanation of how the procedure takes place.
One of the ways to address it then would be to go to the county court conference and work with them on a model colloquy. But it just doesn't seem, again, and I respect what you're saying, and that this is something that may come back to haunt a defendant, because there are cases that talk about if there is an imminent threat of prosecution. But there is no case that says that in all civil traffic cases, that a defendant cannot be compelled to give testimony.
According to Traffic Rule of Court, 6.340, an individual may offer, 6.450, subsection C, the defendant may offer sworn testimony. This is the defendant's decision, and to not inform individuals that are not educated, that are not lawyers, of the actual rules of court, and then allow a judge the opportunity to basically take advantage of that by telling the individual, okay, what do you have to say, when clearly the state's witnesses have not presented enough evidence. A classic situation is an accident case. There's 3 witnesses subpoenaed, only 1 appears. The 1 witness didn't see anything. There's no case. And then they turn to the defendant. What happened? Oh, well, I did this. Well, okay, well, then you're guilty. That person had a right not to testify already under the rules.
But where is that right? You say it's in the rules, but then earlier you said it was in Levitt's, our case.
I believe that.
I've looked at that, and that is very weak ground for your argument. If I understand Levitt's was just saying that when when certain offenses were decriminalized, that didn't violate due process. And there's some general statement in there that due process rights still apply. Well, obviously, in any kind of proceeding, due process rights apply. The question is what process is due in the particular context. But there's nothing in there about this right against self-incrimination, is there?
We believe that it is. Based upon the court's ruling, the court said there was no attempt to limit individuals' rights by the decriminalization. It was just simply an option to resolve more easily. It was never intended to eliminate rights that individuals had under the Constitution. And section number 9 specifically talks about the right to remain silent, and the court was then transferring what was a criminal right, even though it's been decriminalized, to a civil infraction hearing, that same constitutional due process rights.
Are you familiar with the cases that talk about that the privilege may be asserted by a witness during a civil proceeding if the witness has reasonable grounds to believe that his or her answers will provide a link in the chain of evidence necessary for a criminal conviction? Those cases that say that if there's a substantial and real threat, that's when you can assert your right?
But people aren't told that. And then
But that is a determination a judge would have to make. It's not a blanket right. It's a right depending on the circumstances.
We would disagree based upon the language of the Rule 6.450 that says the defendant may offer testimony. The defendant does not have to. It says it right there in the rule. And when you look at Levitt's and Johnson, this was done to make...
What specific language in Levitt's are you relying on?
I'm just relying on the last paragraph that is undisputed, that if one chooses to contest a traffic citation, all constitutional due process rights are available. And then we looked at the Florida Constitution, we looked at section number 9, where there's the right to remain silent. So the court transferred these rights over, even though it decriminalized it, because it was never intended to eliminate or limit people's rights in traffic infraction hearings. And I'd like to reserve the rest of my time.
One more thing before you sit down. Assuming you're right, if a person asserts the right against self-incrimination in a traffic infraction, because it is a civil proceeding, the magistrate could apply an adverse inference, couldn't he?
We disagree. This court has held in Johnson that this is civil in nature. These are not civil proceedings. These are traffic proceedings. We are a separate wing of the court. We have our own central set of rules. We don't have the right to discovery. If this is a civil case, I want depositions. I want interrogatories. I want requests to produce. I want requests to admit. I want third-party production. And I want sanctions when they don't comply. I don't have the right to any of that. The only rights you have in traffic court is the right to remain silent and the right to see a police officer's documents before a speeding case and to cross-examine and to give closing statements, all the other things that are available in all of the proceedings. But these are not civil cases, and that's the one thing that we're hoping that this court will take away, is that we're recognized as a distinct area of the law, separate and apart from civil and criminal, as both types of law are encompassed in traffic. It's a criminal burden of proof.
Good morning. May it please the Court, Chief Justice, Justices. I'm Robert Lee. I'm the chair of the Civil Division of County Court in Broward County, and I'm sent here on behalf of the Conference of County Court Judges, as well as the judges and traffic hearing officers of the 17th Judicial Circuit.
Can you tell us in the real world of all around the state, what do judges do when you have an unrepresented litigant?
This court has imposed a training requirement on hearing officers that is actually in the traffic court rules. So we do ours in Broward about every 5 years. It's not uniform when it's done. We joined with Palm Beach this year to do ours together. One of the things that we do tell them that they have to give a colloquy. We have developed our own model colloquy that we use because there is not a model colloquy in the rules. There's just some suggestions of what will facilitate. And one of the things, however, that we do instruct our hearing officers, as well as in Broward County, the 11 judges that handle civil traffic infractions, is that they are to ask the defendant if there's anything they want to say.
But now the question, I guess, is that if it is a case where it's a serious traffic infraction that has resulted in serious injuries or maybe death now, and the person is not represented, isn't there a concern that if you ask them if there's anything that they'd like to say, that if you don't say that, and what you say may be used against you, so are they required to answer questions? I guess that would be, you ask if there's anything you'd like to say, but if they say no, there isn't, what is the traffic infraction officer then to
Okay, Justice Perriente, getting to the first part of the question, there is, and our hearing officers and judges recognize there's a major difference between having a citation for an out tail light and careless driving that results in an accident where somebody is injured. But again, in any case, and it doesn't have to be just in traffic, it can be in general civil, landlord-tenant, our judges and hearing officers are attuned to those issues and know this inquiry, if it goes down that road, is going to trigger a concern. And we simply don't do it unless we advise them. I have a question I'd like to ask you.
Concern saying, I'd like to ask you questions.
I'd like to ask you some questions, but I'm concerned that if you do, you may be facing some other criminal situation, so it may be in your best interest not to say anything.
So
that is common practice.
But wouldn't then, I don't think this rule is the solution. Could we charge the county conference with proposing a model colloquy that could be put in the rules? Wouldn't that be maybe, in different circumstances? Because this sounds like, again, there's a big difference between the taillight that's out, where the defendant or whatever what are they called?
We call them defendants.
Defendants might want to explain himself or herself, and the one where that the person is coming in, a young, somebody young who is not represented, who may face those charges. We don't want to. You're saying there isn't a one-size-fits-all, but yet how do we make sure they're properly advised?
I believe, and the other concern with that is also the issue of that also is going to trigger a legislatively created privilege, the accident report privilege. And again, our judges and hearing officers are very conscientious about that. But as this court has said, privileges can be waived as well. Sometimes people nonetheless will tell their story even when you advise them that there is this privilege out there.
But there isn't, again, so that's what we're trying. Is there a privilege or isn't there?
In the example you just gave, there is a privilege, the accident report privilege. If the person admitted to the officer they were driving the car, and then I want to question them on that as a judge, the accident report privilege would protect that.
Well, that's in a civil case.
Right, that's a total separate issue than what we're here on today, where a judge, and I do want to, if I can, bring back to the Johnson case, which is a pronouncement of this court back in 1977, only 2 years after the legislature decriminalized most traffic infractions, because that case actually sets forth the reasons we did this in Florida. And there are still states that haven't done it. Our neighbor Georgia still has only criminal traffic there.
Let me ask you, is there a real problem out there? I'm trying to see what we're trying to fix here. And is there a real problem with unrepresented defendants coming into a traffic infraction hearing, and then something that they say in those hearings being used at a later date against them? I thought you...
I'm not aware of one case. I've been on the bench in 15 years, and I was in the criminal division for 8, and I've since then been in the civil division, and I supervised the civil traffic in my circuit. I'm not aware of one, but and it may also be because in our circuit, if there is an accident that may trigger criminal, that is going to go with the criminal investigation and not be filed as a civil traffic infraction until a decision is made that it's not going to be filed as a criminal matter.
And do you know if that's done in other circuits? Or?
I'll be honest with you, Justice Quince, I do not know.
Well, we know there's no cases out there that actually address it, so whether everyone's just been fortunate that they haven't been caught in having their testimony used against them, or just there is some protections that are built in an informal way?
There are really three main areas where this comes up often. One is, keep in mind, in traffic court, we deal with juveniles. So we have juveniles and adults. So sometimes we are, and as this court said in 1977, when you're trying to make an inquiry as to the best way to change behavior, I believe that's the language you used, sometimes you have to talk to the teenager and the parents about what can we do.
And so, but in those circumstances, what, if anything, I mean, I seem to recall at some point you couldn't use what goes on in a traffic infraction hearing at a later date, but what can, in fact, be used if the defendant actually gives some testimony at a traffic infraction hearing? Can that be used in a later proceeding?
And again, I to a certain extent, I agree with Mr. Abramson. I believe that if they plead an out-and-out guilty, because it is the same burden of proof, the legislature created the same burden of proof, you could argue that a plea of guilty would be. But
tell me how we get there, though, because as I understand it, it used to be for all the years you would have at the scene, you would receive a piece of paper that we refer to as a ticket. Mm-hmm. And on the back of it, it has a box to check, correct?
Okay.
And it has something that's called nolo contendere, or guilty, doesn't it? And if someone checks the guilty, sends in their money, it was considered a guilty plea. The statute says that it's not admissible.
The citation is not.
The plea of guilty is not. The admission is not. What am I missing? And then
I guess the best example.
Somebody come to a hearing?
I guess the best example is when you plead guilty, and then you're now, if 3 years later, the issue is whether you're going to be habitualized as a traffic violator for getting 3 guilties on a driving while license suspended within a 5-year period.
Well, that's a different issue.
Right, and so there are instances where it can be, but it's not.
That's not the issue I'm talking about. Okay. That's a totally different issue. The issue is whether the admission can come in connection with this event. Now, do people have hearings just to come in and plead guilty when they could have mailed it in? Is that what happens?
Yes, and just as
an
example,
after you explain to them what it is that happened, they didn't think they violated the law, but then you talk with them and you say, yes, that's technically a violation. They say, okay, then I'm guilty. Is that how this comes down?
We have about 5,000 of these per week in my county.
I'm sure. I've seen the numbers.
And there's over 2 million a year in the state of Florida. Right. And in all honesty, there is a view from many people that you're going to get a better break if you go before the judge because the schedule fine is so high.
Okay.
And that frequently does in fact happen.
So as a matter of fact, it does happen. They do not mail it in.
And if
they
you
lose the protection of that cannot be used as an admission, go in for a hearing where it can be used, that's what you're saying, and plead guilty.
And if you mail it in, you get points. If you see the judge may say no points.
Okay. So it's a practical considerations we have to look at here.
Yeah, and so that's because the statute says that if they elect to pay a civil penalty, is deemed to have admitted the infraction, it precludes those admissions from being used as evidence. But we really don't have then that if they do something else, that the legislature has not said it can't be used. Correct?
Correct.
But this is why, going back to, and it's really a question that I have, I don't see how we pass something that says no accused person shall be compelled to give testimony against himself or herself, which is talking about testimony, when we're talking about the fact that they may say, I plead guilty. So but what you're saying is what happens in the real world is that the hearing officer is taught to look at what the nature is of the infraction and make a discretionary decision as to whether or not that case may go further and have other implications.
Right.
Now, would they do that also because there's many times that this may not be a criminal case, but it may be a personal injury case. There may be injuries, and I remember way back when saying, "Leah, have someone go if that person testifies, because we want to use that testimony in the civil case." What happens in those situations?
In that instance, two thoughts come to mind. Number one, keep in mind that this court has decided through your rulemaking authority that once there is an injury or a death involving a civil traffic infraction, it must go before a judge. It can't go before a hearing officer. And
so then the traffic court rules don't apply?
No, they do apply.
Oh, okay.
It's the judge sitting in his capacity or her capacity as a civil traffic judge in that instance. So that judge hopefully is more experienced and trained to handle that issue.
But if experienced and trained, what do they? I guess still the question is, what do they? If you were instructing me, it's my first day on the bench, you say, unrepresented defendant, where the traffic case has resulted in injuries or death, and I'm now before, and I say, I think I'm probably guilty. What do you say to me?
In that specific instance, and again, I have to confine my response to my circuit because I don't know if the other circuits necessarily do what we do, it would not be in the civil traffic proceeding if a decision had already not been made by the state attorney's office that no criminal charges were going to be filed. So once that happens, I would treat it like anything else by saying it is now your time to say anything if you would like. If you would like to question any of these witnesses, you may do that too. When a pro se litigant cross-examines a police officer, they inevitably, it seems, start to tell their story. So it does create some practical administrative issues if you're going to say to them, you have the right to remain silent, but you do have the right to cross-examine the witness. So there are a lot of concerns, which is why the conference, when we looked at this, we have lists of things that the different judges keep emailing that are problematic there. But that's, but again, in Broward, I just don't see that concern would come to fruition. Our conference is in 4 weeks, and perhaps we can ask the other circuits if they have a different.
You were getting ready to talk about, I think, Johnson case. Back in 77 or so when this was first set up. Is there something that you wanted to address there?
In the Johnson case?
Yeah.
Well, I just wanted to point out some of the language that this court used in its incarnation back in 1977. This court said that this proceeding, the whole reason for decriminalization was to have a proceeding that was informal, where the judge is free to discuss with the offender in an informal manner the best way to remedy, change behavior, protect safety. You also said that inquiry is part of the judicial function, and that the proceedings partake of an inquiry rather than a prosecution. And it's the judge's view that if you cannot have this dialogue with the offender where they're not facing jail, they're not facing probation, they're not facing any type of suspension of a professional license, that it's going to affect the judge's ability to do what this law was intended to do back in 1975.
But it seems as though the proponents are saying that may be all well and good, that may be the intent. But nonetheless, there are these risks that are there for a Florida citizen, and if you don't tell them, they're giving up some valuable rights. That's what the gentleman is saying to us.
And while I agree with that, I do see that risk is in any pro se case that we have, whether it's in a normal garden variety civil non-traffic case, landlord-tenant, where they're accused of tearing up an apartment. It could be where the judges are attuned to know this may trigger that inquiry. That's part of our training, I believe, anyway.
But again, I appreciate how wonderful Broward County is and how advanced you are. But the question, it seems to me, as we sit here in Tallahassee, is that we need to be assured that that's what's happening in the state, that we ought not be treating people differently in Broward County than we do here in Leon County. And that we should all follow the same sort of procedures. We're all covered by the same statutes. And I think we need to be sure that we're not, missing something because Broward is so wonderful that the rest of the other 66 counties are not.
I feel confident that the other 66 counties are likewise wonderful.
Okay.
Thank you very much, Justices.
If I could just briefly respond.
Is that what goes on in all the... again, it sounds from Judge Lee that this isn't a problem because of the way at least it's handled in Broward. Do you have, and we've said there's no cases, we don't, it's like we're creating something that seems that it does, for a problem that it doesn't seem to exist.
Here's our concern. Defendants, by some law enforcement agencies, are subpoenaing defendants to appear. They then have to appear under threat of contempt of court if they don't appear. Even though they don't have to appear under the rules, they're still subject to contempt. They show up, and the judge says, what do you have to say? They tell them they have to testify, and they can be held in contempt if they don't. That is our concern. We've had lawyers threatened with contempt by advising their clients not to be a witness in the case, and we've been threatened with contempt for doing that. That is our major concern.
It's like we have two different worlds going on here. The world of Broward, and then where the place where they're really subpoenaing defendants. Again, we're talking about 2 million traffic cases a year, right?
Right.
So this is I think we're trying to fix something in a way that is not tailored to the particular concerns that you're talking about.
I would just say that the problem is not county to county, it's courtroom to courtroom, which means it's even more imperative for this court to enact this rule.
You mean even within the circuits, they just deal with these differently?
Absolutely.
It's the luck of the draw is what you get?
Absolutely. I had a case not that long ago. The hearing officer didn't even look at my client. Didn't even concern. The witnesses couldn't prove the case. I had it moved for JOA. It was granted. My client was standing right there. Never even thought to ask this person if they had something to say. And if the court looks at Johnson, it says an opportunity is given the offender to offer sworn testimony. It's the defendant's choice. We're concerned not about future criminal prosecutions, but actually walking out of there that day with the case that they should have been found not guilty because the state cannot prove the case beyond a reasonable doubt. There's money involved, there's points on the license, and a judge has the authority to suspend a driver's license. You could find yourself leaving a courtroom without a driver's license based upon your compelled testimony. That is very scary to us as members of the traffic bar. We are doing this mostly out of concern for the people that are not lawyers. And there is nothing wrong with the court simply saying, as a defendant, you enjoy the right not to be a witness in this case. You have all the other rights, cross-examined statement. It's really very, very simple, is not time-consuming. And if you look at the body of the rules of court, as well as the opinions of this case, it's basically saying that. This is the defendant's day. The defendant has that opportunity. I thank this opportunity for appearing before the court.
We thank you both for your argument. We now move to the second case on our docket, in re amendments to the Florida Rules of Juvenile Procedure.
Police and Court. My name is Joel Silvershine. I'm the chair of the Juvenile Rules Committee. I'd like to also say, as a Broward County resident, Broward is a wonderful place to live. It's my honor and pleasure to present the 3-year cycle report of the Florida Juvenile Rules Committee, along with our recommendations for non-emergency changes to the Florida Rules of Juvenile Procedure. Helping me here today are Deborah Schroth, who has led a special subcommittee regarding changes needed due to new legislation, and she'll be a vice chair in the upcoming year. She's going to be handling the dependency issues. Also acting as co-counsel with me is Robert Mason, who's a former chair of the committee and will be coming back as a member of the committee in this upcoming year after serving his 3-year exile from the committee. He's going to be presenting, I will be presenting the delinquency issues with the exception of the immigration issue, because I did prepare the minority report, and I do wish that the majority report be presented in the most complete manner as possible.
And who's going to present the report that a colloquy should be given on the immigration? That's what
Mr. Mason's going to be presenting the majority position that it should be given. I have the minority position that it should not be included as part of the rule.
As to all of these rules, it appears that that's the really only one that has drawn comments, has drawn opposition to the proposals.
There's been no comments to any of the rules that we've had.
Well, I mean, that's the only one that there's some dispute or discussion about.
Well, I leave it up to the court whether or not they have any questions about any of the issues, especially dealing with dependency as well.
My point being is that these rules have come out.
Yes, sir.
They've been published for comment. And we have whittled this down now really to just that one rule that appears to have some commentary on both sides of the issue.
That's correct.
Is that a fair statement?
That is a fair statement.
All right.
There is one other one I just have a question about, and it's a statute was passed in the last year that says that under certain circumstances the judge can close the courtroom in a juvenile delinquency proceeding.
I'm trying to think of...
Okay,
there's one that is pending that just got passed. We're going to be considering that issue in the upcoming year, if that's the 803 that I'm talking about.
I thought there was a rule that was tracking a statute that talked about... let's see here.
Yes, there is a rule that mentions the question of open court, and then
open court, correct.
Yeah,
yes.
And there's some parenthetical discussions.
And I guess my question there is that's a change. In juvenile proceedings, but it's a statutory change.
Statutory change.
Is there any concerns about the constitutionality of that?
As far as having an open or closed courtroom,
yes.
The only thing I can tell you is I know in TPR proceedings that is a closed proceeding. I thought this was for juvenile delinquency. Right.
I just guess my concern there would be I don't know how it's going to be used, but if it's a statute, there's no reason for the rule just to track a statute, and shouldn't it just play out? I mean, the press may have a question about something being closed or opened. What's the guidelines for a judge deciding to close the courtroom or not?
Our guidelines are basically this, that we have to provide rules which comply with a statute, which makes the system work. And if the legislature has passed this one particular thing, we have to make a proposal to this court to implement that.
But it's no different. You haven't changed what the statute says, have you?
Right.
You've just mirrored the statute. I know Justice Wells always used to go, I don't understand why we have a rule that just says what the statute says. If it's a procedure, then the legislature overstepped its bounds, but it's something substantive, which is whether there is open or closed proceedings.
Correct.
That's not just a procedure. You haven't given, and again, if you're not prepared to discuss it, that one just raised a concern. And right now, the press hasn't said anything about it. I don't know how it would be applied. I don't know why it was done, but that's a significant change.
And it's something, we have our meeting coming up on the 21st of June, and I will make sure that it will be discussed.
But right now, it merely says that pleas are to be taken in open court.
Correct.
But then it provides that may be closed as provided by law. It does not say it can or cannot. It depends on the underlying general law that would be applicable.
That's correct.
That's the way we stand right now under these rules.
Right. That's the way we tend to leave things as provided by law, so we're not consistently coming back to this court asking for rule changes.
Okay.
If the court wants to deal with the immigration issue, I'm more than prepared to reserve what time I have and let Mr. Mason make his presentation to the court.
And then are you going to come back?
I'm going to come back. I asked
because I do want to understand.
Reserve whatever time I have left. Thank you.
Okay.
Good morning. May it please the court. My name is Rob Basin. I'm a past chair of the Juvenile Court Rules Committee. This court should adopt the amendment to the Rule 8.090 because the children of Florida should not be subjected to deportation without fair notice or fair warning.
Well, here's the problem. There's two problems. First of all, they say a child can't be subject to deportation because of a juvenile delinquency adjudication. So you're going to scare that child about something that can't happen.
Well, I agree with the minority position that the conviction alone, meaning this piece of paper that says you've been convicted for a Juvenile Delinquency Act, a juvenile cannot be deported or inadmissible based on this piece of paper.
At least as of today.
As of today.
I mean, we don't know what the future is going to hold in this area.
No, sir.
It seems to change from time to time.
But a child can be deported by the underlying facts behind what is from that piece of paper. That's why we changed the rule. The adult rule talks about how the plea may subject you to this deportation. We changed the rule for juvenile saying the facts underlying the plea may subject you. The history of the rule, this was all pre-Padilla. We had passed this rule. It was included in the original 2009 three-year packet. And at the very last opportunity, we withdrew it because of the concern from the Devison case that you've referenced, that a juvenile conviction is not treated as an adult conviction. We understand that. It's not an adult conviction where you have your aggravated felonies or your crimes of moral turpitude or your firearms that are mandatory. And in a way, that makes it even easier, and in a way, it makes it even more persuasive that this rule should be before the court.
Would you give us an example of what may be a typical delinquent act that would then be used, the underlying facts, for a deportation proceeding that we should concern ourselves with, and that's why the rule was adopted?
Well, possession of drugs.
All right, keep it played out. What happens?
If a child has a possession of drugs, possession of drug paraphernalia, that is one of the acts that can be deemed bad conduct, and those are separate grounds on why someone can be deported. It's not just limited to these mandatory grounds of the firearms and the aggravated felonies and the moral turpitude. There's other grounds. If there's prohibitive behavior by non-citizens, that is what can be used to...
Let me ask you just a practical question about deportation of a juvenile. I would assume that in most instances a juvenile non-citizen would be here with their parents or some adult. Correct.
Sometimes they're even in foster care.
And so, assuming we're not talking about a foster care person, what happens? A juvenile is actually deported without the parents being deported, or this is of concern to me because I'm not sure how this would work practically.
I think there could be a snowball effect. I think the attention that's brought onto the juvenile potentially could make it more likely if there's any grounds for the parents to be deported. That could also happen.
Well, I guess
but you don't know that as a practical matter that is what happens.
No, ma'am.
I think the problem I have is, first of all, after Padilla, I think we got to change the adult plea colloquy because it's not a may, it's changed. But the basic thing to me that's changed with Padilla is the obligation of the attorney who is advising either the adult or the child that this is not, and it's why it's so critical to think of for a child who is not legally in this country as a result of, I guess, the parents having brought this child over or abandoning the child, that the attorney know that this may be a offense that under the facts may subject that child to deportation. So we're really at the tip of the iceberg here. If by a judge just saying this may subject you to the facts may subject you to deportation, well then the question is what fact? We're really then we're not giving any information.
But I think this actually solves the dilemma on post-litigation for Padilla, because Padilla basically says if it's mandatory deportation, you need to tell your client it's mandatory. If it might happen, you need to tell them it might happen. You have to say something. In juvenile, it will never be mandatory deportation. So we lose that part of Padilla. So what that means is you might be deported. By having this in the plea colloquy, every child is warned of that possibility. So we're not going to come back in a situation years later, post-litigation.
And you're saying the child is going to understand that?
Well, the pleas and the colloquies have to mean something. And it's a situation where if an attorney has not discussed the immigration issues with the child or with the parent, when the court says you understand that this may have some immigration consequences. There's plenty of times where during the plea colloquy when a judge says something, that basically stops the colloquy of no, I don't understand. And the case is passed for further discussion. See,
But wouldn't it be, I'm trying to understand, because we've had this argument already in the adult context. So you're coming behind it with, we've already had the full argument on what Padilla means, what it means in Florida, and that kind of thing. But let me just if a youth is caught with a grocery bag full of cocaine, and they come before the juvenile court, and it's within the jurisdiction, whatever we have, and it's not processed as an adult matter, it's not it's that you will be if you plead, yes, I have these underlying facts, I had a bag of cocaine.
No, sir, it's not mandatory. It may or may not.
It is only if there's a conviction it's mandatory?
No, it's just the conduct, the facts from the trial, admissions from the trial, they might be used against you. There's nothing mandatory the way they were.
Well, I think what Justice Lewis was asking is a certain type of criminal conviction that results in the mandatory or virtually mandatory deportation, and that doesn't apply here.
Correct.
Even if the underlying facts that would match up with that crime, that's what I'm asking, with absent the piece of paper conviction, they're not mandatory.
Correct. There's not any mandatory deportation for any juveniles.
It would really help. This would what we had in the Padilla case. We had the group of immigration attorneys giving examples, real life examples. I think that you raised a lot of. For me, it's a concern here, but it would be really helpful to know, has something like this happened? And I understand also what Justice Lewis says. Just because it hasn't happened yet, it could happen in the future.
Well, children have been deported, and when we first withdrew this rule...
Well, I'm sure children have been deported. Have they been deported for something they did
yes,
as
when this rule was first withdrawn, the delinquency subcommittee reconvened on it. We talked to attorneys around the state. We talked to other experts around the state, and we came to the conclusion, based on what we heard, children were being deported because of facts underlying juvenile delinquency matters, and that's why at the next meeting we passed it, and then
not mandatorily.
Not mandatorily, though.
Because you see, this is pretty much the same colloquy that we had with adults.
Yes, sir.
But it may be in violation of Padilla because of the mandatory nature of some of those. There's nothing, you're telling this court, there is nothing, no factual admission that a child can make that would ever create a mandatory deportation circumstance.
That's my understanding, yes, sir.
Okay.
I think it really solves the dilemma of someone coming back years later saying, I never would have entered this plea, my attorney didn't mention this to me. If we have it in the plea colloquy, we have it there.
Well, I know that doesn't really solve the problem of whether a defense attorney who's faced with a child that's in this country illegally has some greater obligation if they know they're in the country illegally and they know the facts may subject them to deportation, and make sure they don't testify. If they don't testify, well, anyway, I guess your time is up. It's just, in other words, I think that the obligation of a defense attorney isn't going to be eliminated by a colloquy that's given to every youth that pleads by saying the facts may subject you to deportation. A 12-year-old, as Justice Perry was saying, what's that going to mean to them?
I agree with you.
But just one other question. But this isn't just limited to aliens who are here illegally, is it? Aren't we talking about anyone who is not a U.S. citizen?
Anyone who's trying to become a U.S. citizen. You could also be inadmissible.
Okay. But if they're a citizen, they can't be deported.
That's correct.
Well, I said someone who is here that is not a citizen.
Right. Okay,
but
a
is here
non-citizen.
legally.
Gotcha. It would apply to a non-citizen, yes. Any non-citizen.
Thank you.
I guess.
On behalf of the minority position,
can I ask you this? Is this
yes.
You're an attorney?
I'm a prosecutor in Broward County, and I do post-conviction work, and I've done hundreds of cases involving immigration, including State versus Green, which I had in the lower level.
That was the adult.
That was the adult case where this court said you have 2 years from the time you enter your plea to raise the post-conviction motion.
So what's the problem with this?
The problem with this is that if this were to be given, it'd be misadvice.
It would be misadvice? Is that what you're saying?
If this would be misadvice, it would be misadvice because you cannot be deported based on an adjudication of
But he's saying it refers to facts, that the facts underlying this.
I have never seen it. And I've been doing post-conviction for 21 years.
That's all I'm asking. Is there a distinction? You're saying no, that it's impossible for someone to be deported on the basis of not a conviction, but facts that have been admitted in connection with a guilty plea.
I can say I've never seen it.
But you've never seen it.
Remember, Title 8, USC Section 1227 lists all the things for which you can be deported.
Right.
8 USC 1227 describes certain things which tend to be mandatory in nature, such as drug crimes. Also mentions domestic violence.
Well, what does he refer to when he says bad behavior of a Jew? Is there no kind of a discretionary thing that if a kid is just has gotten in fights, is doing all these things?
I haven't seen it.
Why? You haven't seen it in Broward. We talked about how great Broward is. We're talking,
What's the law? What's the federal law? That's the question.
The federal law is 8 USC 1227 as grounds for those are the things.
But is there a catch-all bad behavior type of thing? I mean, don't look like there is. He's saying there is. We don't have it in front of us. We need to know what the federal law says.
I don't recall there being anything about that. And
Well, wait a minute. You don't recall. This is a issue that is here before us. And do you not know if there's a federal law? I'm not trying to be difficult here, but it's important to us to know what the federal law is. And if the federal law is as the person on the other side indicates, then if it's not that way, you ought to be able to point that out to us, it seems to me.
Well, the thing is, 8 USC 1227 speaks to criminal conduct. Criminal conduct. And what courts have described for over 60 years, there are cases in Devison which go back to 1944, which say that juvenile delinquency is not the criminal conduct that they're talking about.
But you can have conduct that you can admit to, separate and apart from the conviction for that conduct. Is that true or is that not true? That's the distinction that's being made, as I understand it, this morning. And this could be a very critical issue.
I would have to look at the statute again. Okay. I don't want to mislead the court in any way, but I have never seen anything like that. I have not been placed with I have not seen any empirical evidence of anybody being deported based on that. But I also need to note to the court that it has to be the sole reason for deportation. Was mentioned about illegal aliens. If you're an illegal alien, if you're not supposed to be in the country, that's an independent reason for you to be deported. I think this would be more important to somebody who is a legal resident of the country.
Okay, a legal resident.
Right.
And this happens to him. What's the effect?
Well, that's the effect of a finding of juvenile delinquency.
No. An admission of engaging in the behavior that would be criminal under our statute. Child admits, I had a bag of cocaine. Okay. No conviction, no finding of delinquency. But admits that I had that bag of cocaine. Is that person subject, again, that's a resident alien, is that a basis for deporting that person?
I see my time is run out here, but
you can answer the question.
I hope you don't. That's the crux of what we need to know.
Okay, I can check it out. I cannot tell you offhand. I don't have the statute in front of me. I would have to see the statute in front of me. But 8 USC 1227 is what I'm concerned about. What I'm also concerned about is a situation where that colloquy that particular line is given, and somebody who might have an otherwise favorable plea bargain rejects it, goes to an evidentiary hearing, goes to an adjudicatory hearing, is found guilty, and is committed something given a more harsh penalty than that person might have received, and then alleging in a post-conviction motion under 8.140 about misadvice.
Well, but the question here is a pure question of law under the federal immigration laws, isn't it? I mean, that's something we ought to be able to figure out.
Yes, sir.
What the law requires, or what is possible under the federal immigration law.
Right.
And if it's possible that based on something that happens in a juvenile case, a plea, that a juvenile can be subjected to deportation, then saying that may happen is not misadvice.
However, that has to be, you also have to look at, are we opening up a can of worms when we get into that reverse situation? Especially when the law for over 60 years has recognized that a finding of juvenile delinquency is not a basis for deportation. Thank you. I thank the court. Deborah Schroth is going to speak on the dependency issues. Thank you.
May it please the court, I'm Deborah Schroth, and I too am a past chair of the Juvenile Court Rules Committee. We seem to recycle ourselves every 3 years. There are a couple of rules that are more than technical changes. We have a lot of proposed technical changes to you, and I don't think they bear discussion unless any of the justices have questions. One of the primary changes that we're asking concerns an adjudication of paternity in the context of the juvenile dependency case. And I know that you've been asking questions this morning of, is there a practical need for this? And indeed, there is a practical need for this rule. We do not have any uniformity around the state as to what to do when you have a father who is the biological father but has no legal claim at the moment to be the biological father. We have multiple variations of this situation in court. We have legal fathers because we're finding now, especially in this economy, that many people never bother to divorce. And so we have husbands and wives who are scattered and have no access to one another for years, and the new man steps up, or there's a new wife and you have a whole new family, but that family can't marry because...
Are you talking about Rule 8.225 now?
Yes, Your Honor.
Okay.
Yes, ma'am.
And so what is the actual change that you want to make?
The primary changes are to make it clear that the dependency court has the authority to actually enter the determination of paternity, because we now have some judges around the state who say you have to go off to family law court, especially in those areas where we don't have a unified family law
So this
division.
would require someone in a juvenile proceeding to actually question paternity. The juvenile judge would then order whatever kind of task you order to determine paternity and all of this? I mean, is this a whole new procedure for juvenile?
I'm sorry, Your Honor. The proposal does not speak to DNA testing. What the proposal says is, and there is the colloquy that the court has to engage in with the mother of the child is already in statute, that if you do not have a legal father, the court has the obligation to ask the mother all these questions to try to determine if there is some man who is likely the dad.
And to what end? What are we trying to accomplish here?
What we're trying to accomplish is to ensure that all of the dependency courts understand that they have the authority to actually make a determination that this man who has come forward and said, I am the father, and signed an affidavit of paternity, that the dependency court has the legal authority to enter the order, instead of having to say, now you, sir, have to run off to a different division of this court, which is one of the situations that we see happening in various courts around the state.
And then the juvenile court would do what with that information?
Well, the juvenile court would find that this man is the father, and then that man would become a party in the proceedings. It would allow the court to place the child with that man as the father of the child, if that was appropriate. It would also clarify termination of parental rights proceedings if neither of the parents was appropriate and met the requirements for termination. We would have a determination that this man is the father, and then we would be able to terminate that man's parental rights.
Are we doing all this just to figure out which court they're going to? Did I hear that correctly?
That is part of it, yes, Your Honor, because we do have, as I said, some dependency judges who do not believe that they have the authorization to actually make the finding that this man is the father.
But as to termination of parental rights and so forth, I mean, that could be, it might be a substantive issue in another case, or it may not. It seems like we're doing an awful lot here to decide substantive issues if all we're doing is trying to figure out which court they're going to.
The proposal does not address any substantive issues. It just addresses what the trial court is supposed to do when you have the situation of these competing, either no man as the legal father or competing men to be the fathers. Right now we have confusion in the different courts of the state, and different courts do it differently, and some courts just, well, I'm not going to make that decision. And unless the man who says, or two men who say, I am the father of this child, unless they actually go off to another court and file a Chapter 742 proceeding, we end up with a child with parentage unknown.
Well, in the context of the rule, what is the rule used for to determine the identity of the parent?
The only thing that the rule is really used for is to set up what the procedure is, so that the court, the dependency court, has the authorization to sign off saying you are the father and you are a party.
For what purpose? Why do they determine the identity of the parent?
Because we need to know who the father is for purposes of reunification, if possible reunification is appropriate. We have, not every unwed father is inappropriate to parent the child, but we end up with situations where there is a real father, a biological father standing there, and the court will not recognize him unless he goes off to a different division of the circuit court to file a paternity action.
You know what troubles me a little bit here is it seems that I understand what you're saying. We haven't really had opposition to this for a real thorough legal briefing of everything that's involved, and it's within a section that tells us process, searches, and service of pleadings and papers. Yes. I mean, this is pretty substantive stuff. Mm-hmm. I mean, that's the only thing that concerns me. That, I mean, if we're going to do this, why wouldn't we prefer to have this in a separate rule rather than under the, you know, who's going to get served? I mean, that's the crux of a lot of these things, isn't it?
Well, the difficulty is that the legislature actually addresses in Chapter 39 the issue of how the court is supposed to look for the unknown parent. Right. In the section on process and service. And so the legislature kind of set up this construct, and the Rules Committee has followed it. But
it's not, I mean, the whole process from 742 that's set forth in a process section, is it?
I mean, I agree with you that it would have been more ideal, I guess, if we had pulled these subsections out and created a separate rule for them. And if it's possible, it seems like this is
my concern is this is flying under the radar. That's what my concern is, that this is something that is way beyond just service of process and searches, and it's the guts of who's the parent for the child and who that kind of thing. And I may be wrong, but it just seems to me, it's just as a lawyer sitting here, I would have never put it and hidden it there. I use that word not in a negative way, but this just seems to be. It seems to be just like stuck in there.
Well, in defense of our committee, Your Honor, we have quite a bit of explanation in our petition that accompanies the rule. So if there are attorneys in the state of Florida who are concerned about this, if they'd only read the 12 12 pages, 10 pages of our petition, we do explicate that. We didn't hide it from other people being able to brief it. And I understand.
It's just buried in here.
Right. We didn't bury it.
The thing is that this issue about who's the father and the due process issues involved usually generates some controversy. And so on your committee, in terms of the dependency, did you have lawyers that represent fathers as well as children? Is there a diversity on the committee, and nobody disagreed that this rule, or was it unanimous?
I believe that it was.
3 abstentions.
Certainly when we got to the vote of the full committee.
Well, again, the full committee, though, has juvenile juvenile court members that may not really be engaged in what the question is.
It was a vote of 15 to 0 to 3. So we had 3 abstentions and 15 folks voting in favor of it.
It really does seem that there is an awful lot of substance put into this particular rule, and I'm just not sure where it all ends up. I mean, if there's a petition before the court and there's no father, does this give the juvenile court the authority to go start looking? And I'm just a little bit concerned. The more you talk about this rule, that there's a lot more to it than it just, initially appeared.
Your Honor, my time is up. But
you may continue.
Thank you, sir. The substance of this is already in Chapter 39. We've not created anything new other than giving the dependency court a set of procedures to follow. The court already has the obligation to ensure that we've made a diligent inquiry as to who the...
But I thought you said earlier that the court did not believe it had the authority to, in fact, determine the paternity.
Right.
Okay.
The courts are required to ensure the diligent inquiry. The courts are required to ask the mother or any other family members who come to court questions designed to get at who the biological father of the child is, or who the legal father of the child is if we have a legal father. The one thing that is missing in all of this is an assurance to the dependency judges that after they find out who this man is, that they can say, as a matter of law, you are the father. What we have now are dependency courts saying, okay, you've stood up here and you've said you're the father. You may have signed the birth certificate. The mother says you're the father, but I'm not going to say you're the father until you go over to the family law division and file a 742 proceeding. And these people don't have the money to do that. It doesn't happen, and so we proceed with a technically unknown father.
Unless they have a unified family court, and then they can deal with it.
Absolutely, unless they do, but we still don't have that in every circuit.
Okay.
Thank you very much.
All right. We thank all of you for your argument today. The court will now...
No, I didn't know. Yeah.
The court will now stand in recess for 10 minutes.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
We now come to the third case on today's docket, Puglisi versus the State of Florida.
May it please the Court. My name is Melanie Casper from the Office of Criminal Conflict and Civil Regional Counsel in the 4th District on behalf of the petitioner Vincent Puglisi. Mr. Puglisi was convicted of first-degree murder in Palm Beach County in a death penalty trial. The issue in this case is when the client and the attorney disagree at trial on what witnesses to call, whose decision is it ultimately to decide? This court in Blanco versus State said the ultimate decision is the defendant's. In Kane versus State, the 5th DCA, relying on Blanco in 1990, agreed and said it's not who is in charge and who is running the trial. The attorney clearly is in charge, but the ultimate decision on what the ultimate decision is the defendant's. And the 4th DCA in this case recognized this court's decision in Blanco and found it in opposite of our case.
Let me ask you this. Why should it be the defendant's ultimate decision as to what witnesses should be called? It seems to me that we have a lot of case law that talks about the fact that the attorney has the obligation for trial strategy and those kinds of issues. And isn't the calling of witnesses a part of trial strategy? So why should a defendant have that right?
Well, the strategy in the questions to ask the witnesses, I believe, should be the attorney's function. But what witnesses to call, especially in this particular case, because we're not looking backward, we're looking forward, that it's not hindsight. We're looking at the defendant having a fundamental disagreement with his attorneys on the record, and the defendant saying, this is my only chance here. And the defendant and the attorney are at odds, and the trial court goes through a long colloquy trying to figure out why the defense attorneys do not want to call this witness, pushing the limits almost to ask to waive attorney-client privilege at that point. The defendant doesn't understand. He just says, this is my life and my only hope here. This is a death penalty trial. The co-defendant is prepared to come in and be the only person that can support the defense's theory, ultimately.
So is your position based on the fact that this is a death penalty trial? But we're looking at cases in general, because obviously this really is not a death penalty trial, because he didn't get it may have been at the time of trial, but he didn't get the death penalty. So we're looking at this case, all criminal cases. And so does it make a difference that this started out as a death penalty trial?
It doesn't for the rule which witness to call, but in the client's mind at the time, he was saying, I'm facing this death penalty and I want to call this witness. And then we create sort of a conflict, it seems, between the attorney and the client at trial.
Well, this is where people look at a legal system and say, it's an asylum with the folks having mental illness are running the show. This is not one where the witness, as I understand it, is going to exculpate, is going to give an alibi, is going to set this guy free. Weren't there prior statements taken, and this guy flips and flops and incorporate and implicates him and says he did it? And this is not something where you can say this witness A would have won this case. That's nowhere near this case, is it?
Well, actually, I respectfully disagree that actually Mr. Ditto did make different statements at different times, but what the defense attorneys were ultimately trying to flesh out when they took his deposition during trial over the weekend was, what is he going to say at trial, and are there prior consistent statements?
Prior statements?
He did have prior inconsistent statements saying that Mr. Puglisi was involved, but however, during the deposition...
So it is true. We don't have a Mr. Clean standing there, angel, ready to come in and testify. This is a case that you've got a witness that's all over the board and a lawyer making a decision on who's going to be a witness in this case. It just seems to me that we either let the lawyers, under these circumstances, represent the individuals, or let the defendant try his entire case. I mean, when you get down to what I don't want to ask that question. Oh, he should have asked this question. It just seems to me that this is just no common sense in this. Help me, please.
I want to, Justice. There are two issues involved with that. First, with Mr. Ditto, the defense attorney, Ms. Howitt, the public defender in Palm Beach County, was trying to ask the judge for the continuance to go back and look at prior consistent statements that apparently Mr. Ditto made in 2006 when the murders occurred, saying that our client was not involved. So there were prior inconsistent and prior consistent statements that ultimately the public defender's office was not able to flesh out in the limited amount of time that they had.
Wasn't there a concern? The prosecutor, I think, represented to the court that Ditto had said that he probably would lie and testify consistently with his previous statement that the defendant in this case did it. Isn't that a concern for a defense counsel that once the guy takes a stand and raises his right hand, there's no telling what he's going to say?
Yes, Judge. That was in the Brady notice that the state attorney did file. However, when the public defender's office and the state attorney's office took the deposition of Mr. Ditto, he said, "No, I'm going to tell the truth when I take the stand." So
during that deposition,
during the trial recess deposition, correct, which was actually done with all counsel present. So Mr. Ditto, yes, there were inconsistent statements. There was. But there was desperation with Mr. Puglisi. If you look at the colloquy where he says, "This is my only chance. My defense here is that I didn't do anything."
See, I can just see.
Isn't this a classic case where deferring to the trial counsel's strategy prevented your client from receiving the death penalty? Had he been allowed to bring this witness on and he was given the death penalty, then you would come in and say, well, he shouldn't have allowed him to testify because he received the death penalty. I mean, I'm trying to make this make sense. As Justice Lewis said, it just doesn't make walking around sense.
Well, Justice, with the decisions that the defense attorney makes, that Ms. Howitt makes, if you look at it, she's still saying, we're trying to determine if we're going to call this guy. So it doesn't clearly show a strategy.
Well,
it shows.
And I keep on thinking as I listen to this that we must be here on post-conviction. We're not. We're here on a direct appeal. It may be in the world of post-conviction that if Mr. Puglisi brings a motion for post-conviction relief and says it was not reasonable strategy, and that the public defender's office wasn't prepared. We hear that all the time, and then it's going to be a decision down the road as to whether it was reasonable strategy. Our decision here, as I understand it, is not whether it's reasonable strategy. You're asking for a rule of law that when a defendant wants to call a witness and the defense attorney does not objects, says I do not want to call that witness, that the judge would overrule the defense attorney's decision and say we're calling that witness. It would be the same as the defendant's right to whether, because it's his right or her right whether to testify.
Correct.
His right or her right whether to represent himself or herself. We have all sorts of crazy things that go on in trials. So the fact of having a marginally competent defendant represent himself, unfortunately, that happens all too often. But isn't that what we're talking about here? Not whether it's reasonable or not, because that will be a post-conviction decision, and it's not apparent on the face of the record. But is that the rule you're asking for, that in every case it is up to the defendant, if it's a dispute between the defense lawyer and the defendant as to which witnesses to call, that because the defendant is the captain of his ship, even if the ship is going to go sail down to the death penalty route, to make that decision, because it's ultimately his life that's at stake?
Yes, and
so yes, the answer is the rule of law would be that when there's a dispute, that the right to call witnesses and which witnesses to call is the defendant's, not the defense attorney's.
Yes.
Not whether it's a reasonable strategic decision, because that's going to be the question if it comes up in a post-conviction proceeding.
That's correct. That would be a 3850 issue in the reasonable strategy.
Now, I don't know if I agree with you or not, but I want to make sure it's not a question of whether it was a good idea or not a good idea to call a witness. That's the rule you're asking for.
Yes, it is.
So the question I have is, where do you draw the line? What happens when the defendant says, I want to give the opening statement, I want to give the closing statement, I want to do the cross-examination? At what point in time can a judge step in and say, no, look, your counsel is representing you? I mean, the way I see it, this is a question of a fundamental right on the part of the defendant. And I see there are four things that I view as fundamental, and that's pleading guilty, waiving the jury. That's obviously a decision only a defendant can make. Whether he testifies or not, that's a decision that only he can make or she can make. And the right to appeal. But now you're adding to that list the right to call witnesses, the right to choose which juror is going to serve, all these other things. Where do you draw the line?
Well, I'm relying on this court's case in Blanco, and I did certify the conflict based on that in good faith, because at the 4th District Court of Appeal, I did not file the briefs. The Public Defender's Office filed those and withdrew after the briefs were completed. And I was following that through, that based on Blanco and based on Kane, that the ultimate decision is the defendant's. And drawing the line, that's the problem. It's a bright line that we can't draw, because the defendant, his right to a trial is a right to a fair trial, and we're looking at the circumstances in this case, and it is difficult to say, in all cases, a defendant gets to call whatever witness a defendant wants to call, and a defendant gets to give an opening statement, a defendant gets to give a closing statement. But in Kane, the 5th DCA says it's not who's representing the defendant. Clearly the lawyer is, but even looking at the Strickland case, not in the 3850 sense, but looking at what's required is that the attorney is to look at alternative courses of action, discuss things with the attorney is supposed to discuss this with the client, and there's supposed to be attorney-client communication here.
But if the defendant is going to have the ultimate decision about all of these trial matters, then why in the world does the defendant even need a lawyer?
Well, the attorney is to provide assistance and give alternative courses of action. The attorney is to give the...
It seems, and please understand, we're not trying to shoot the messenger. Mm-hmm. You do understand
Absolutely.
that. We do have to flesh out this because this is a thorny problem. But you are describing a bifurcated type of representation where you have standby counsel, and the lawyer's got some responsibility, the defendant does some other, and haven't we said clearly in our case law that you're not entitled to both?
That's
defendant
correct.
can file this pleading, and the lawyer has to file. I mean, that's the problem we're into, isn't it?
It is, and it does become difficult because you don't want to do that, but you're creating a conflict between what the attorney wants to do and the defendant wants to do, and how do we resolve that?
Well, we lose total credibility if we say, the lawyer's just there to parrot whatever a defendant wants. I mean, that's a sham system. And we have a mechanism so you can get rid of the lawyer if you truly want to do it yourself, don't we?
Yes.
And isn't that the way that it's done? If you don't want that lawyer, and that lawyer's doing what he or she should do, there is a mechanism for ridding yourself of that lawyer, but there was no request to get rid of him. Just, I want to control what he does, isn't it?
I think it was clear that the defendant was not getting along with the attorneys, as you can tell from the colloquy, but the defendant didn't really clearly know what to do because the judge was trying to get him to waive attorney-client privilege, and he just didn't understand the process and probably didn't understand, I can discharge my attorneys in the middle of trial. Is that the smartest thing to do? I'm not sure.
Isn't what this really is about? The defendant really doesn't understand the process and the nuances of calling certain witnesses and what that door that portends to open that can really kill him, so to speak.
Absolutely, but the problem that we have here is what the defense attorney, what Ms. Howitt, the public defender, says is she still didn't make it as a strategic decision. She says we're still trying to decide if we're going to call him. We still need to find out about his prior consistent statements. So it's clear that the defendant's in the courtroom. He hears that. He doesn't understand.
But ultimately, the attorney says they're not going to call the defendant. So the question is still the same, whether or not they were, a little bit concerned about whether there were other witnesses to support the defendant's, the co-defendant, I guess it was, statement or not. The ultimate question really still comes down to, is this a matter of trial strategy that is in the control of the attorney, or are we going to turn over these items which are not necessarily fundamental to the defendant? I know you said you relied on Blanco, but maybe Blanco was incorrectly decided.
If that's what this court ultimately decides, but I am relying on Blanco because the defendant did have the right to bring that forward.
Let me ask you this. Are you familiar with the U.S. Supreme Court decision in Taylor versus Illinois? Well, let me quote you. And what I'm quoting is not a holding, because there was a focus on a particular narrow question about whether the defendant was going to be bound by the attorney's decision not to list a witness prior to trial. There was a tactical decision made there. But what the court said in the course of discussing that issue was they recognized that there are certain basic rights, the rights that Justice Labarga has already mentioned, but aside from those, the lawyer has and must have full authority to manage and conduct the trial. The adversary process could not function effectively if every tactical decision required client approval. And I think that's the point that Justice Lewis was making about we've got to get in contact with reality here. And the court goes on there to say, putting to one side the exceptional cases in which counsel is ineffective, the client must accept the consequences of the lawyer's decision to forego cross-examination, to decide not to put certain witnesses on the stand, or to decide not to disclose the identity of certain witnesses in advance of trial, which was what was at issue here. But it seems like that the position you're taking is really very much inconsistent with what the Supreme Court said there. And I realize they weren't addressing this specific question. But why isn't your position inconsistent with the broad outlines of their discussion here?
Well, I don't know what context that case was in, if it was in an ineffective context, but that, again, is why I'm saying that this case is not a 3.850 at this juncture, because we're not looking in hindsight and saying, he said, she said. We actually have the record where it shows that the defense attorney doesn't even think that's the strategy at one point.
But you're not asking, you're asking for a ruling in this case, yes, for a reversal. But the rule that we would have to adopt is that there was a constitutional right for the defendant, among the other rights that Justice Labarga mentioned, to be able to have the right as to which witnesses to call and which witnesses not to call. Whether it can't be based on, well, in this one there were more consistent statements than prior inconsistent statements, because that's no rule of law, right? Wouldn't that have to, this would have to be that this is his constitutional rights were violated by the judge not following his request as opposed to the attorney's request. Isn't that what we'd have to decide?
Right, and this would be,
so that's a broad leap from other cases that have been decided in the narrow scope of what the defendant does have the right to do.
Right, but to be able to generally just say it's strategy becomes very difficult, too, because the defendant can't overcome that hurdle. It's very difficult to overcome that hurdle, especially when you look at the context of the defense attorney saying, we're not even sure.
Well, that's not the issue in this proceeding. That may be the issue in some other proceeding, but whether that was strategy shouldn't be the issue, I think, if we're looking for a rule of law that says who gets to call the witness.
Right.
You are now down to a little more than a minute.
Okay. At this point, Mr. Puglisi, at trial, had the right to determine what witnesses to call based on this court's holding in Blanco and in Kane versus State in the 5th DCA, and that does create a conflict with the 4th District's opinion in this case. Thank you.
Good morning. Good morning. May it please the court. My name is Sue Ellen Kenny. I'm an assistant attorney general representing the state of Florida in this matter.
You still need to do something with the mic, yes.
Okay. Can you hear me better now?
Yeah.
Great. We would respectfully disagree with counsel regarding the holdings in Blanco and Kane.
But let's talk about Blanco and Kane, because both of them seem to say to me that the defendant has the ultimate decision on trial strategy. And so if that is the case, why shouldn't the defendant in this case have been able to say, I want that co-defendant to testify, even though I know he's been all over the board and his statements?
Those cases we would submit stand for the proposition that if the trial court gives you, Mr. Defendant, what you want, you cannot be heard on appeal to complain that you got exactly what you asked for.
So in Blanco, we do know that the trial judge allowed the defendant to allow the witness to testify that the defendant wanted to testify. Is that correct?
That's correct. And in Kane, it was the defendant picking the ultimate composition of the jury. And
so that's an odd situation, which is that the trial judge in this case could have granted Mr. Peclusi's request, even though the defense attorney did not think it was a good idea.
I don't think that it would have been proper. However, I don't think it would have been appealable. I don't think it would have been an appealable issue had he done that.
Here's a strange thing as I think about it. I think ultimately it can't expand the constitutional rights in this way as a blanket rule. But let's talk about whether to testify or not. Obviously, the defendant can't be compelled to testify. And we see if the defendant wants to testify, even though the defense attorney thinks it's the worst idea in the world, does he have or she have a constitutional right to testify?
No. The defendant, yes.
Now, okay, because what is the basis for that constitutional right that they have, even though they're going to seal their own fate? What is the basis for them saying that I have a right to defend myself because it's my life at stake? What's the basis for that in the Constitution? Is that under the due process? Because again, the right is not to be compelled.
Not to be compelled to incriminate oneself.
You say, and we've seen this again in the death, we've seen every variety of crazy things go on in the death penalty cases, that a defendant takes the stand against the advice of the attorney. So what's the derivation for why that is a constitutional right of the defendant?
These are decisions that he can only make in terms of the four outlined decisions that Justice Labarga had.
No, I'm not asking. I understand it's case law says it. I'm asking you, what's the derivation of that right that it's the worst decision in the world for that defendant to testify because he has given 20 different statements and he has 20 convictions. He goes, I want to tell my story. What's the basis for that?
Well, isn't the flip side of not being forced to be compelled to be a witness against oneself?
But there's no right. Okay, so this is where what I'm going to is this. If you have that right, the question, my co-defendant is going to exonerate me. I don't want to testify, but my co-defendant, it's going to be I want my co-defendant who is willing to testify to testify. This is my life. That's what I want. I'm not sure I understand in the context of what we have allowed or what the Constitution allows why the ability to call a witness is that different from whether the defendant has to testify. Now, there may be, and I haven't looked at it, but does it strike you that if it is stupid strategy for a defendant to testify, but it's his life, that if he wants his co-defendant who's willing to testify, that he shouldn't have that right to be able to call that co-defendant?
Again, I think maybe I'm not understanding the question, but I'm telling that is an issue of trial strategy. Why would you have the lawyer there to make these strategic decisions?
Well, again, we have seen, even though we talk about what's crazy, we have death cases where the defendant makes the opening statement and then the lawyers do this, and then the next thing, because at each stage you have to re-ask whether you want a lawyer, so the lawyer comes back in, and then we got the defense, then the defendant gives the closing. I mean, we have things that are not the way we would think a trial should be conducted, because there are these rights of self-determination under Florida about what it is, and I agree there's no hybrid, but after where a defendant wants to testify, it's because they're the master of their destiny. Even, and you say, why wouldn't there be a lawyer there? The lawyer has said, no, it's not a good idea. The defendant there gets to trump the decision of the lawyer, correct?
Correct.
So I'm asking you, why, if it's the co-defendant who is going to be able to say that this guy didn't do it, why isn't it their equal constitutional right to allow that, not go to each question, but as to a witness that he believes, wrongly maybe, and again, under Blanco, if it's done, he can't complain of it, to be allowed to call that witness?
But your decision as a defendant to testify is personal to you. And calling a witness, that's not your right that you're advocating regarding compelling to be a witness against yourself.
It's your constitutional right to testify.
And it's not your constitutional right
but there is
to micromanage.
Again, I guess that's what I'm saying.
Yeah.
The constitutional right is not to testify.
Right. And the flip side of that, or I guess the inverse of that.
And that's, you think, how that came out of the Fifth Amendment? That's
the
where you
5th
think
and the 14th through the states.
Did you agree this can be subject of a post-conviction as to whether it was reasonable strategy or not?
Certainly. Certainly. And that's where examination of this type of issue belongs, not here on direct appeal where we're talking about the attorney having the authority to manage the defense and the strategy without being micromanaged as to what needs to be done. The attorney has the experience and the training and the overall view to figure out whether or not this witness is going to be more helpful than not. And in this case, whether this witness was going to testify really wasn't going to do anything regarding Mr. Puglisi's initial confession to the police back in 2006.
In terms of the self-determination, I know in a death penalty case, the defendant has, we talked about the rights, they have a right not to present mitigation, correct?
Correct.
Where does that come from? In other words, there's rights. Does the defendant have the right to say, I don't want you to call the witnesses, as opposed to calling the witnesses? Is that where that would come from?
I'm not entirely
in death penalty cases,
yes.
When you get to the mitigation phase,
right.
The defendant has an absolute right not to present mitigation.
And the attorney still needs to investigate that mitigation,
yes.
Despite
so the right not to present mitigation, which may be, in the end, subject that defendant to the death penalty, because now there will be no mitigation heard by the jury, is their right.
And not being as familiar with the death cases that you are, I would venture to say that it's probably something that's particular within the penalty phase and the way that you've bifurcated it. I'm not able to answer it further than that because I'm not familiar with capital cases.
Is it anywhere analogous maybe to the right not to even have a jury trial? I was trying to focus here on where rights, as Justice Perriens has been coming from, and you have the right, and we've already testified about that, is you have the right to waive a jury trial, correct?
Correct.
And so does that spill over? Is that how you get to, in the penalty phase, you have a right not to do the...
And that may well be...
I just want to make sure we're, as we look at this, and some of the rights, because they derive from different constitutional provisions, like under Ferretta and self-representation. I mean, if up to me, I would not... I think it's the most, you have to see the transcripts in these cases where these defendants come in and out, and you just going, it is crazy. But we have to allow it because of a constitutional provision. So I just want to make sure that our jurisprudence on this is consistent in terms of what rights are afforded to the defendant, so that we at least have a good rationale for it. And you may, I'll look back at that mitigation situation. It may come from exactly what Justice Quinn says,
but all four of the rights that were listed in the Barnes and then again talked about in Burke are emanating right from the federal Constitution and the amendments. And here we've got no personal right, it's tactics. And again, we would say that in terms of the conflict here, this has always been the rule. Kane and Blanco don't hold otherwise. They just hold that you're not going to be able to get your way at trial and then turn around and say, nope, that was wrong. Trial attorney shouldn't have given me what I asked for. But to the extent that Kane or Blanco may be read that way, we'll see how the law has specifically evolved. And you look at the Nixon case.
When was Blanco decided?
1983,
84.
84, excuse me.
And have we made any pronouncements about these kinds of issues since Blanco?
Well, we had in terms of this particular issue,
yes.
No. But we've got all of the post-conviction cases where in this case, or this court has specifically found those are tactical decisions. These are strategic decisions that are made by counsel, not being made by the defendant. And
Article 1, Section 16 of the Florida Constitution says rights of accused and of victims. And it says that in all criminal prosecutions, a defendant shall have the right to have compulsory process for witnesses, to confront at trial adverse witnesses, to be heard in person by counsel or both, and it goes on. So I guess the question I have is, have we interpreted what it means to shall have the right to have compulsory process for witnesses to be of a constitutional nature that is the defendants as opposed to counsels? Do you know if we have any case law on that particular provision?
That I don't know. I'm sorry, that wasn't one of the points that we had discussed.
It seems pretty important, because as I was trying to find where any of the rights, at least under the Florida Constitution, might come from, and so it looked like a good idea to go right to the Florida Constitution, and of course it has there the right to have a speedy and public trial by an impartial jury, which again is their right to waive that. So it seemed that that we're saying what they can waive, which is, I guess, if they say we don't want to call any witnesses, would the defendant have that right? That they instruct their counsel not to call any witnesses, even though counsel says, I think you should call witnesses. Maybe that's where do you think that so the flip side is that here the defendant doesn't want to call witnesses in the guilt phase, and
in the guilt phase, we're not dealing with
in the guilt phase, and the defense lawyer says you should. Does the defendant have the right not to call any witnesses?
The defendant at that point then has the right to fire counsel.
So it is really so it's not, even though but in the jury trial it's an absolute right, or to testify or not is an absolute right without firing counsel. So I'm trying to see why the witness, if they don't want to call witnesses, why they would then have a right only to do that if they fire counsel.
Well, in terms of the compulsory, they have the right to compel witnesses. They're able to bring the witnesses forward if they want them forward. If they don't want them forward, that you can't force the attorney to call the witness and issue the subpoena, which is the power that we're compelling the witnesses to testify with. At least that's my understanding of the compulsion, would be the power to issue the subpoenas to get the witnesses in court and have the authority of the court behind them. And that If the attorney decides he wants to call or she wants to call certain witnesses, then they would be able to use the power of the subpoena to have those witnesses present. If they decide they don't want to use them as a matter of tactics or strategy, then they're not going to exercise or use that right that was accorded to the defendants generally, to have them brought into court or forced into court against their wills in terms of the witnesses. In terms of our case and Florida law, we do have the Nixon case that came down recently, well, fairly recently, that again delineated these are our 4 rights. These are the 4 fundamental rights that if they're going to be waived in any manner, they have to be personally waived.
Did you say the Nixon case?
Excuse me, Nixon.
Nixon. So you can concede his guilt and...
Right. You can concede...
And that's not fundamental.
That's right.
That's what the U.S. Supreme Court said.
Well, in Harvey, this court said it. But yes.
But in Nixon, that's what the U.S. Supreme Court said.
Yes, that's what the U.S. Supreme Court said.
That was their teaching.
Pardon me?
That was their teaching.
Yes. And in Harvey, this court followed that opinion.
Well, we know. Well, following what the U.S. Supreme Court says is we don't have that option, do we?
Right.
Not to follow.
That's true. And again, it was delineated that these are the only rights that you've got that must be personally waived. Deciding which witnesses to call is not one of those rights that must be personally waived by the defendant. And when we're looking through, as recent as I think it was 2004 that the Nixon opinion came out, this is what, again, is being reiterated. The law has never changed. The law has always been the attorney gets to call the tactics and the strategy. It's the defendant who gets to choose to exercise or not exercise his 4 fundamental rights during the trial, whether to appeal. And much like I think it's the Barnes opinion that originally listed the 4, telling appellate counsel basically what you can and can't do.
But it's really not, again, as you said, there's a right not to appeal, but in death penalty cases, we require that there be an appeal. Now, they said this wasn't a death penalty case, but it could, it was, they were seeking the death penalty. So it just seems like there is, maybe, again, it's a product of the U.S. Supreme Court opinions that we're guided by, but we also have our own state constitution, that the issue of calling or not calling witnesses seems that it falls within the same category of important rights that should be the defendant's decision.
Such as conceding guilt?
Well, I wasn't. They overturned at least some of, a majority of our courts. So to say that it's consistent is not what we're talking about. We're talking about whether they haven't addressed this issue, have they?
And my understanding regarding, and again, I'm not as familiar with the capital issues that you are, is that even if the defendant doesn't want to appeal, it's not that it's the appeal that you're looking at, it's your ability as the Supreme Court to review it. So he doesn't have to choose to file the notice of appeal, doesn't have to choose to have the attorneys bring this forward, but you as the court want to review all of the death cases to make sure that nothing's going to come through that's going to be disproportionate. And that was how my understanding of how the capital worked, was that it was for the benefit of this court to review everything so that there was no disparity. So I think it's a little different. I think it's a little different when we're dealing with the right to refuse to appeal in capital and in the regular criminal matters, because I think you do have that component where this court wants to review regardless of who wants to take the appeal or whether nobody wants to take the appeal. And in terms of this particular case, even if you were to find that we want to expand the fundamental rights, any error in this particular case would have been harmless, based on the complete lack of credibility of Mr. Ditto, his various inconsistent statements, but more importantly, you have Mr. Puglisi, his confession, and the corroborating physical evidence to the confession. I'm sorry, I see the red light. If there are no further questions.
Thank you. And the harmless error, I just wanted to bring up the fact that the culpable negligence instruction was given to the jury, but they were unable to consider it. It was not on the verdict form, and that Mr. Puglisi's confession would have been consistent with a lot of what Mr. Ditto testified, and that Mr. Puglisi was not, he stood there looking shocked, things to that nature. The lawyer's function is to present alternative courses of action, not to make decisions in contravention to his client.
Just to follow up on that last about Mr. Puglisi, was Mr. Puglisi subject to conviction just being there?
No.
So what would you have to show in order to sustain his conviction?
Well, it depends on, you mean for the first-degree murder conviction? Or if there were lessers given to the jury?
So for the first-degree murder conviction,
it would have to show that he
was a principal,
correct,
right?
yes,
Okay.
exactly.
And what do you have to show a principal?
That he intended for the crime to happen, that he did something to assist the crime. Okay. The counsel's functions to assist the defendant, not to make decisions in contravention of the client's wishes. And just quickly with Nixon, the client consented to the strategy through his behavior, and that was something that the court found. And in U.S. versus Burke, the 11th Circuit said that the list was not exhaustive in the fundamental rights list. And I see that my time has expired, and thank you for your time.
All right. We thank you both for your argument. That concludes today's session of court. Court is adjourned.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.